Well, welcome everyone in person and to our large Zoom audience tuning in. Thank you so much for spending a Friday morning here with us to learn about student discipline. I think you're going to enjoy it. I think you're going to learn a lot. I think it's going to be fun. Thank you for the introductions. And I just want to thank again Albany Law School, Chell Miller, Pat Wild, and Lisa Rivage, and everyone else who has helped us put this together. We really appreciate it. We've had a great partnership with Albany Law School over the past few years, including many interns and graduates like Erika, who have, I think everyone's benefited from it. It's been a wonderful relationship. So we're here today to talk about the how and why of student suspensions in New York. As you're going to learn, the State Education Department has a unique role to play in that process. This presentation actually began as an email summary. My colleague Whitney Bronlin, for those of you on Zoom, who I'm looking at right now, suggested to me and said, hey, that could be a CLE. So thanks to her and Erika, that became a reality. So thank you to the support of you both and others in Office of Counsel. So since there have been schools, there's been a need to reprimand misbehaving children. For any of you parents listening or in the room, you understand that children are agents of chaos. But what's the best way to deal with that? How do you balance the goals of preserving order in a classroom with educating disruptive children? There have been conflicting philosophies over time. The goal of this presentation is to explain the prevailing philosophies from the very beginning of the public school system in the early 19th century to the present. You really can't understand the decisions and holdings that we're going to talk about without understanding the historical and cultural context. So the slide that's up here is an outline of what we're going to be talking about. I won't read each one, but you can see largely we're going to go chronologically from the very start to the third section is kind of a big pivot point, the enactment of Education Law 3214 to the present. And here's some of the things that I want you to think about as we go through each of these periods. Why suspend students at all, right? And I think it's not too controversial. The definition of a suspension is removing a child from an educational environment. They're not allowed to go to school. So some of the reason you might want to do this, you'll see on the left: preserve order, keep kids safe, educate or rehabilitate a student, and punishment. So that's, not to give away too much of the presentation, but that's been the prevailing philosophy over time. But we now know, looking at the column on the right, that punishment and suspension has risks. So some of them are here: mistaken identity, depriving a child of an education that they can't get back, implicit bias, and other lasting harm. So before we get started, I'd like to share a personal story about student discipline. So when I was in second grade, West Sand Lake Elementary, for any locals who may be here or listening, a bunch of kids in the class came up to me and said, hey, I got an idea. Let's go to the back of the classroom and we're going to write all the swear words we know. And for reasons that are somewhat unclear to me, I said yes. So we go to the back of the classroom. We have one of those black and white composition notebooks and went to town. And of course, kids never think they're going to be caught. My teacher came over, saw the whole thing, and we were busted. So of course, my heart drops, to my stomach, and I'm very worried about what's going to happen. My teacher took me aside and said, Dan, you know better than to do that, right? And I said, yes. And that was it. So she did not call my parents. She did not pursue the matter further. She could probably see the look of terror on my face that this made an impression. And to this day, I have not written down a list of swear words ever again. But I think that that has left a lasting impression in me as I think about the children involved in these appeals, and have my own children thinking about whether, how they would be in this situation. So Erika, do you want to share a story about discipline as well?
Yes. So When I was a senior in high school, I was given 1 day of in-school suspension. Long story short, some drama broke out during a marching band trip, of all places, over, a missing t-shirt. It escalated into me being accused of spreading rumors and threatening another student, another girl. None of these claims were proven. I still stand by that. It's been 11 years. Um, I was suspended the weekend before my marching band state championship. So to me, this was, the end of the world. I was never going to play with the marching band ever again. It was my senior year, and, I was devastated. But the principal still let me participate, and it was a whole back and forth because technically it was against the code of conduct, but I was still able to participate. Um, and I had never gotten in trouble before. I was, uh, for lack of a better term, I was a goody two shoes in school. Hung out with the bad kids, but I never got in trouble myself until this incident. And it kind of shocked my friends and like the school and everything. And actually, I showed Dan a picture yesterday. One of my classmates took my picture while I was in ISS and put it on Instagram and said, Erika has ISS, because they couldn't believe it. So, that was my experience with student discipline. And, the chancellor of the Board of Regents had once asked how many of us would be where we are today if no one had ever been given a second chance. Uh, and in my case, I wasn't given the grace that Dan was, where I knew you're better than that. It was, we don't know if you actually did this, but we're just going to punish you because I want to. And even though it wasn't a second chance, here I am today. So,
Yeah. Yeah. The decisions made by adults have big effects
yeah.
on kids. So before, sadly, that's the end of the personal stories, and we're gonna we're gonna take a trip back in time briefly. So let's talk about before we get into what's the state education department doing and has been doing. How did we get to a administrative agency weighing in on all of this? Our agency, the State Education Department, is actually a combination of two agencies. The first was the Board of Regents. They originally were the trustees of King's College, later Columbia, and then eventually granted the ability to oversee all of higher education. And you can see 1784. They predate the Constitution. It's interesting. And 1784 is the formal enactment of the Regents and statute. The second part of it is the State Education Department, and that has to do with a larger cultural movement, starting with industrialism, which coincided with the social movement known as the Second Great Awakening, a national movement of religious revival characterized by appeals to emotion and revelation. The Second Great Awakening also had a social component. Many reformers sought to purify their souls by purifying society. This reforming impulse manifested in a mission to improve public education. There were two main goals. The first was to standardize instruction for teachers. This involves the creation of normal schools, you may have heard, usually called teachers' colleges now, and increase state assistance to local schools. And local schools in the very early 19th century are exactly the stereotype you're thinking about: one-room schoolhouses, generally supported by a local community. Not unlike later social reform movements like the New Deal and the Great Society, education reform was a top-down affair. The first reformers sought to utilize the power of towns, villages, and cities, and, to an extent, the state, to improve the quality of local education. This state authority grew exponentially in the 19th century. Prior to that time, the legislature supported common schools, these little one-room schoolhouses, through periodic appropriations toward a state fund. The fund, in turn, gave the money to cities and towns. In 1812, the legislature took the first step towards centralizing public educations by entrusting the creation and growth of school districts to a new state official, the superintendent of common schools. So centralization, districts, it's the process of taking little one-room schoolhouses and yoking them together into a group for efficiencies and to have a unified unit. In 1854, the legislature created the Department of Public Instruction to oversee public education. When it did so, it took that superintendent of common schools, moved that individual over, and renamed them the superintendent for public instruction. And the final piece to this confusing patchwork creation of our agency is 1904. So through the 19th century, you have the regents, which oversee higher education. You have the Department of Public Instruction seeing this K through really 8 public schools, and high schools emerged as a jurisdictional turf war. That both of those agencies were like, we want to regulate high schools. It's a classic lawyer issue. The regents are like, high school is more like a college. And the K-12 8 agency says, no, it's more like a public school for young kids. So after much to do in the legislature, the solution was to smush them together. So what you have is the regents become the governing board of the Department of Public Instruction, renamed SED, and the head of that agency was renamed the Commissioner of Education. This compromise is reflected in the New York Constitution, which provides that the regents' corporate powers may only be increased, modified, or diminished by the legislature. And one important piece about this, so you can see, this has always been an independent legislative agency. At no time has SED reported to the governor. And I'm going to turn it to Erika.
So we're going to talk a lot about the Commissioner of Education today. So here's some more information about her powers and duties. She serves as the CEO of the State Education Department. She's appointed by the Board of Regents, and she serves at their pleasure. So like Dan just stated, we don't answer to the governor, we answer to the Board of Regents. Right now, there are no statutory qualifications to serve as a commissioner, but typically, the commissioner has a history in education, superintendent, teaching of some sort. The commissioner has wide-ranging statutory responsibilities. She's tasked with enforcing all general and special laws relating to the educational system of the state and all educational policies determined upon by the Board of Regents. So like the regents, the commissioner has the authority to visit and inspect all educational institutions within the state. Perhaps her most unique power is the responsibility to resolve quasi-judicial decisions. The commissioner has appellate jurisdiction over controversies arising from public schools. This power, contained in Educational Law Section 310, has existed for over 200 years. And through this 310 process is how we have these discipline appeals. Generally, this works like a simplified appellate process. The complaining party files a petition, which the respondent, who's almost always a school district, has to respond to. The practice regulations also allow for reply and memo of law. The Court of Appeals has held that an appeal to the commissioner is intended to serve as an expeditious and simple method by which the many questions bound to arise in the administration of the school system can be resolved. This is reflected in the relative simplicity of the procedure and the 30-day statute of limitations. Some common subject areas that we see in these appeals include residency, homelessness, transportation, and the topic we're discussing today, discipline. Importantly, the commissioner has the power to consider educational policy when deciding quasi-judicial appeals. As the third department has stated, the commissioner is not subject to the same rules which constrain the courts and can take into account educational policy matters and substitute her own judgment for that of the officer whose actions she's reviewing. So in previous discipline appeals in previous decades, the commissioner would see a discipline appeal, especially in this case, find it overly excessive and reduce it. But now the commissioner normally will just expunge the entire suspension if it's too excessive.
Yeah. Great, thank you. So now, with all that background in mind, we can jump into the earliest decisions of the commissioner on this topic. So believe it or not, 150 years can be covered in a relatively short time and with a relatively short number of decisions. The two themes that emerged are on the slides here. So education was, the teachers were understood to be stepping into the role of the parents. Parents were seen as having almost unbridled authority over children. Children weren't seen as legal beings with legal rights. They were more like property that parents had the power, but really you'll see the responsibility was the philosophy to keep them in line and preserve order. So what we understand now as student discipline, kids screwing around in school, that concept doesn't really exist in these decisions. So you'll see it either as one of two categories: corporal punishment or expulsion. Okay, so let's do corporal punishment first. This is using physical force against students as punishment. And believe it or not, it was subject to a reasonableness standard. Here's a quote from a late 19th century decision you have in your materials. The school law is silent on the subject of corporal punishment, but the state education department has uniformly ruled that the force or violence used must be reasonable in manner and moderate in degree. The penal law contained a prohibition on assault. However, there was an exception for parents or, quote, any guardian, master, or teacher who struck a child to restrain or correct the child. So most decisions in this early time period upheld corporal punishment. A great example is a 1924 appeal, which again you have, matter of Stanbro, where the commissioner upheld a principal hitting 4 students with a, quote, heavy, thick rubber hose. And this is a local appeal, by the way. This occurred in Colony. The parents of the children who were hit by the hose sought removal of the principal from her position and revocation of her teaching license. The decision, interestingly, does not disclose what the kids were doing to warrant getting hit by the hose, but the commissioner had little sympathy for them, noting that the principal had taught in New York for 8 years. This was the first time she had been accused of abuse, and the parents had not filed a civil or criminal complaint. The decision did contain a mild admonishment. The commissioner characterized the hose hitting as, quote, not wise, and an act that, quote, merited severe criticism. However, the commissioner said no remedy was warranted because the children were not permanently injured, nor so injured that they were unable to attend to their regular duties. So this was another world from where we are now. And my colleagues know I'm very opposed to AI use and find that it generally lowers and degrades the quality of written work. But AI did produce this image of the appeal we've just discussed. And I think it did a pretty good job. Erika will talk about expulsion and other punishments.
So while the commissioner generally endorsed corporal punishments, appeals concerning conduct other than reasonable physical force reflect the beginning of limitations on local discretion. Of particular concern were arbitrary displays of authority that served no educational purpose. The first is from 1872. Here, an 11-year-old student committed what was described as a light offense. The teacher then demanded that the student ask pardon upon his knees or else he would be expelled. The student refused. On appeal, the commissioner reinstated the student, describing the begging on your knees demand as an act of petty tyranny.
I love that.
Yeah, love that. I'm putting that in my vocabulary. A second is from the following year, 1873. A student was caught whispering in class, and as a punishment, the teacher forced the student to sit near a very hot stove. The student was subsequently suspended in refusing to acknowledge that he or she had done wrong in declining to submit to improper punishment. The commissioner ordered that the student be reinstated, offering the following explanation. It is a duty of teachers to exercise a sensible discretion in their dealings with the pupils under their charge. To compel a scholar to sit by a hot stove is an improper punishment for any offense. And thanks to AI, here's another photo.
Yes, and look at this. It was the same day, apparently, according to AI, even though these appeals are 50 years apart.
Same classroom. Long day in class.
And so that's important, right? Is that we're already seeing this idea that you can go too far. And as abhorrent as we see corporal punishment, it really was a different conceptual category for parents, educators of 100+ years ago. So Sorry? No. um, so yeah, so lo and behold, we covered 150 years very quickly. But there aren't and another telling aspect is there aren't that many appeals from that time period. So I think that in many cases, parents just accepted that, sure, the school had the right to do as they wished. You have a real groundbreaking moment with the enactment of Education Law 3214. So this was an SED program bill, and it codified a growing judicial consensus that students were entitled to procedural protections before they were excluded from public schools. The story of this procedural right, like so many educational rights stories, goes back to Brown versus Board of Education. I think you're all familiar with that holding, I should hope, but just in case, if not, the holding is that schools cannot, you can't maintain a segregated school and that students have rights to access public school. Many reformers took that idea, well, if I have a right to school, shouldn't it be X, and ran with it. Even modern disability rights owes its origin to the principles of Brown. So after Brown, the federal courts emerged as the best avenue to achieve equality. It took tremendous courage for judges to stand against segregation, and many did. One such stand occurred in 1961 when the Fifth Circuit Court of Appeals upheld minimum due process for St. John Dixon, a student who had been summarily expelled from Alabama State College. His offense, participating in civil rights protests. We're going to spend a few minutes with Dixon because it was the first and most influential opinion in this area. I know most of you didn't come to say, I really want to hear about a Fifth Circuit case from the 1960s, but we'll get there. And it's an interesting dispute. So the Fifth Circuit panel assigned to Dixon was Judge Richard Rivas, Ben Cameron, and John Minor Wisdom. Rivas and Wisdom consistently and courageously upheld the civil rights of African-American plaintiffs during the 1960s and beyond. Cameron did not. He once derisively referred to Rivas and Wisdom and two of his colleagues in a dissenting opinion as, quote, the Four. But this mean nickname stuck and is now a term of endearment. Dixon was a 2-1 decision with, predictably, Cameron dissenting. The majority offered a persuasive argument for due process. It must be conceded that the power to expel is not unlimited and cannot be arbitrarily exercised. There may be arbitrary application of the rule to the facts of a particular case. Indeed, that result is well nigh inevitable when a board hears only one side of the issue, just like Erika's suspension. The court opined that in a case like this alleging misconduct, there should be a hearing, and the student should be given the name of the witnesses against him and an oral or written report on the facts to which each witness testified. The student should also receive the opportunity to present his own defense against the charges and to produce oral testimony or written affidavits or witnesses. Well, Dixon was a higher education case. Federal courts widely adopted in its holding that there should be some minimal due process before students are removed from school. Several of these decisions are cited in Lopez versus Williams, a 1973 trial case. You might know it more for its caption on appeal to the Supreme Court, which was Goss versus Lopez. And some of the New York decisions, federal New York decisions, are in your packet in the bill jacket for Education Law 3214. And let's take a minute for our friends on Zoom to read you the CLE code. This is the first code. It is 04ED. Oh, 04ED. All right, so this, our predecessors at SED came up with this procedural framework for student discipline that persists today. It's divided really into two kinds of suspensions. The first here is 5 days or less. The rights are procedure heavy. So you have to give parents written notice apprising them of their right to an informal conference and to question complaining witnesses. Those who've been involved in education law will like hear these phrases and realize that there's a lot of factual disputes and permutations of, well, who's the complaining witness? Was X a conference? But this is the simplified version of it. And you have to give that written notice prior to suspension, unless the student is a continuing danger. If they are, you still have to provide the notice as soon as possible. It's not an excuse to not deliver it at all. And 6 days or more, long-term suspension. So this is more like St. John Dixon's situation where he was expelled. And this has a lot more procedure, but it's more focused on the merits. You know, so short-term is kind of procedural. Did you get to show up and talk to people? And long-term is more, did you actually do it? So students are entitled to a, quote, fair hearing before the superintendent or a designee. You may cross-examine and call witnesses. You'll get a written decision making findings and recommendation to the board about whether there should be a suspension, if so, how long. There's an appeal right to the Board of Education, and then the commissioner via Education Law 310. And one brief note on what I've called other suspensions, the dreaded other category. There is a almost common law level of due process owed to in-school athletic and extracurricular suspensions. It's similar to the short term, where you have to get notice of what the administrators think you did and an opportunity to discuss, but it doesn't have the written notice component. And that opportunity, just like the short term, should be prior to the suspension, unless it's a continuing danger situation. Right, so that brings us up to
Post-war to post-Columbine era. The 1960s post-war era brought about significant changes to student discipline, and this is what kickstarted the discipline revolution. And significant changes were made to educational policy, specifically with student discipline, through these 310 decisions. These decisions are primarily focused, the three categories I'm going to focus on today are decisions dealing with procedure, the type of behavior that was being disciplined, and the educational value of the discipline being imposed on the students. So the first is procedure. Notice requirements for short and long-term suspensions gave students and parents the right to be informed that the student is being suspended and what they're being suspended for. So now the students are being told, they have to be told that day, you're being suspended for so-and-so activity. And then the discipline hearings were then broken up into two phases, the fact-finding phase and the, for lack of a better term, penalty phase. And during this time, anecdotal records that were part of a student's prior disciplinary history could not be introduced during the fact-finding phase, or could not be used to prove the student's culpability when determining whether or not a student committed a certain charged offense. These were only considered during the penalty phase when the hearing officers recommended the severity or the length of the punishment. And commissioners throughout the decades have consistently reduced or expunged these suspensions where the anecdotal record was improperly considered, to just protect the students' procedural rights and make sure that, just in a regular court proceeding, nothing is improperly, no evidence is improperly considered. And then on a federal level, in the 1970s, the Rehabilitation Act of 1973, Section 504, prohibited discrimination against students with disabilities, and this provided further protection in discipline proceedings. Manifestation determination reviews were required after the fact-finding process or phase, where the student was found to have committed the charged conduct. But this manifestation review, determination review had to happen before the student's discipline was decided. At this review, the student's manifestation team will have to answer two questions. Was the student's conduct a manifestation of their disability, and or was the student's conduct a result of the school failing to properly accommodate the student? If the team answers yes to either one of these questions, the school does not proceed with discipline and the matter is referred to the Committee on Special Education, where the students' accommodations will be addressed. If the team answers no, then the school may proceed with the discipline. And we actually, had a conversation earlier about manifestation determinations. And in my opinion, these are vital to protecting students with disabilities. And I say this as a former recipient of a 504 plan, but I digress. Next slide.
Sure.
And with these procedural decisions comes the appeal of Cuffey. And here the student was permanently suspended from high school without any type of process whatsoever. And here the commissioner decided that the continued attendance at school is a valuable right which should not be denied without the proper safeguards of procedural fairness. Even if a student is expelled, schools have the responsibility to see that every effort is made to provide. Yes. Oh, no, you're fine. I'm so sorry. To provide for the students, the pupil's continued education in circumstances best suited to his needs and abilities. So during this time, the commissioner is starting to, well, we've never really upheld permanent suspensions, but at this time, the commissioner is starting to explain and address the educational values and the procedural protections of these excessive suspensions.
Mm-hmm.
What year was this?
This is
1960.
8 or 9.
Yeah.
Toward the end of the 60s.
Yeah, in the mid 60s. Okay, next slide.
Mm-hmm.
The educational value was also being, decisions also started to reflect on the educational value of these punishments. What does a student gain from such a long suspension? In the appeal of McDonald, a 16-year-old student who was already on social probation for reportedly being involved in an obscene yearbook photo, was permanently suspended when he got into an altercation with a teacher at a school dance. The school did not deprive him of any procedural rights. Everything was fine in that aspect. But during these hearings, the petitioner freely admitted to his involvement in the altercation. He apologized for his actions and he expressed his desire to graduate high school. Even though the petitioner was over the compulsory age of education, because he was over 16 years old and he was not technically entitled to the protections of Education Law 3214, the commissioner found that permanent expulsion was too harsh of a punishment under these circumstances. So in this case, this child showed remorse, showed, he learned from his actions. He's not going to do it again. He wants to graduate. He wants to get his education. And even when kids were not this, remorseful or understanding of what they did wrong, the commissioner would still give them another chance because they understand kids are allowed to make mistakes and not have it be a black mark on their record forever. Decisions addressing the value of excessive punishment on a student were very uncommon, but they were also very inconsistent. And we'll talk more about this in the post-Columbine era because these values tend to kind of go out the door once the post-Columbine era starts. Next slide. Oh, wait, no. Yeah, no, we're good. And finally, the disciplined behavior. As part of my research for this presentation, I read through a lot of student discipline decisions, and I started to notice certain patterns and certain trends. One of the most notable and rather concerning is the amount of students who make threats of violence against the school or bring weapons to campus. In Appeal of Burton, this was in 1977, a 15-year-old girl, we'll call her Cindy, because that's her name, allegedly brought an unloaded handgun to school and she kept it in her purse during the day. She showed it to a few other students and was immediately suspended that day. Cindy admitted to the school that she brought the gun to intimidate students who had been bothering her. She previously complained to her assistant principal that she was being bullied. The assistant principal then informed the students who were Cindy's bullies of Cindy's complaints, who allegedly retaliated against Cindy, making it worse for her experience. After losing faith in the school's ability to help her, Cindy resorted to this scheme of intimidation and bringing a handgun onto campus. Now, despite all this, the commissioner annulled her second charge that Cindy was guilty of endangering the safety of herself and others on campus. Why? Because the students Cindy intended to intimidate didn't know she was packing heat that day. The only danger she posed that day was bringing the gun to school, not endangering, not the intimidating behavior. This varies drastically from the appeal of Forrest Yarrow in 1995, almost 20 years later, when a student brought a pellet gun to school, obviously not a firearm like Cindy did. He pointed it at another student, and he was suspended from November 1994 until June 1996. So that is full school year and then half. The facts supported that the student was just fooling around. He didn't mean to hurt anybody. He wasn't going to hurt anybody. That was not his intention. He's not trying to scare anyone, unlike Cindy. But the commissioner found that bringing gun to schools can't be tolerated. And the fact that no injuries occurred in this case, whether it was intended or accidental, is of little merit. And you can see this is a 180 from the appeal of Burton 20 years before that. And again, this is before the Columbine massacre happened, which kind of reinforces this. You can't make these jokes, you know.
I know.
Okay. And the school shooting at Columbine High School ushered in an era of fear in public schools. It fueled lengthy suspensions on the policies of zero tolerance. As professor of law Derek Black has written, in the panic that followed, the nation ratcheted up its school punishments. Not only would students be expelled for bringing guns and drugs to school, they would be expelled for things like habitual disruption and disrespect. Some schools went so far as to suspend students for chewing Pop-Tarts into the shape of guns and for playing games like cops and robbers when they include imaginary guns. And I do have a quick personal anecdote for this. When I was in high school, we had senior pranks, as most schools do. In my junior year of high school, the senior year prank was a Nerf gun war. And all of the kids reportedly, were not allowed to walk graduation who participated in the Nerf gun war because my principal did not want that to be, normalized, or it wasn't a funny joke. So in response, I remember the ecology teacher and the physics teacher both wore signs that said Nerf guns are not victimless crimes. So it was not taken seriously at all. But this was 10 years ago, and we still see these trends happening. This approach lasted for almost 2 decades thereafter, and we've identified some of the punishments that are highlighted on the screen. In the appeal of Joseph F. specifically, a 15-month suspension was imposed for a telephone bomb threat. In this case, the student had called the school and made this bomb threat days after the Columbine massacre had happened. And while the student did not intend to cause any harm and she just wanted school to be done that day, she just wanted school to close. She's a kid. She thinks that if I call this in, then I'm not going to go to math class tonight at 5, whatever. The commissioner upheld her suspension and said, in the light of the massacre that just happened in Colorado and the fact that bombs were found in the cafeteria at that school, not in Joseph, but in Columbine, it doesn't matter if she intended to make that threat or not. These jokes should not be tolerated, and the students should understand the severity of these threats that they're making. Yeah.
Yeah, and there's two more on the screen that are similar examples. I think 12-month suspension for dumb comments at a student rally. The second one, that was not that long ago. That was probably 10 years ago or so.
Yeah.
So we're not, Joseph F was like on the heels of this, but this really extends almost 2 decades afterward. Well, this brings us to, we had the beginnings of the seeds of this revolution in the 70s, particularly with Commissioners Allen and Nyquist, who served from the 50s into the 70s. But we really hit the student discipline revolution in 2020 to the present. We finally made it to the title. Yes. We're going to do comments at the end. We've left some time for that. So this revolution came about because it really became impossible to reflexively uphold these student suspensions in the face of new legal and policy developments. And these include all of the things you see on your screen, which I will explain in a little more detail. This 2019 guidance, this was joint guidance between the Office of the Attorney General and State Education Department that warned about the dangers of excessive discipline and, quote, urged all districts to fully evaluate whether they over-rely on exclusion as a form of discipline. The Every Student Succeeds Act. This is the latest iteration of the ESEA, passed in the 1960s as an equitable measure to ensure that all students have access to public schools. The most famous rebranding of it may be No Child Left Behind. Its current iteration is ESSA. And ESSA was passed in 2015, and it mandated the creation of state and district level plans to avoid, quote, the overuse of discipline practices that remove students from the classroom, the very danger that Derek Black was talking about in post-Columbine era. So New York State's approved plan recognized goals for school districts, including reducing the overuse of punitive and exclusionary responses to student misbehavior. There's a 2019 resolution of the Board of Regents. The board reaffirmed its commitment to reducing dependence on exclusionary school discipline. And the board, you have this in your material, you have this resolution in your materials. And among the findings that the board made was there are racial disparities with discipline. Students with disabilities, LGBTQ students are at a higher risk of being suspended. Suspension is the first step in a series of events leading to lower student academic achievement, higher truancy, higher dropout, and higher rates of contact with the juvenile and adult justice systems. And the quality of school climate is one of the most critical factors in any school's capacity to promote student achievement. And finally, the CRDC data. So this is data that used to be collected by the United States Department of Education. And it consistently revealed that certain groups are disproportionately suspended. As mentioned, African-American students, students with disabilities are always at the top, and it's intersectional. So if a child fits both of those categories, they are the most likely to be suspended. You have in your materials recommendations of the Safe Schools Task Force that presented to the Board of Regents in 2023. Really disturbingly, the trend of disproportionality didn't change between 2011 and 2017 under the CRDC data. So even though you have ESSA, you have these plans, everyone knows what they shouldn't be doing. It's largely the same. So all of this informed two major developments that comprise what we are calling the student discipline revolution. And I would say it's the scrutiny of proof and educational policy. Those are the two main things. We've also put student-centered here because that's not so much of an independent factor as a global factor that informs every way we think about this, that are these good for kids? All right, so let's do a scrutiny of proof example for you. This is appeal of JR, and unfortunately, the district here did not prove that a student sold acid to another student. The principal came to the hearing, testified about social media interactions, but none of them were introduced into evidence. He also did not know when the alleged sale occurred. So the commissioner sustained this appeal largely based on two errors by the hearing officer. First, the hearing officer didn't issue a subpoena for some relevant witnesses. The commissioner explained that the hearing officer improperly expanded the scope of a court decision that allowed schools to preclude cross-examination of witnesses. It's worth reproducing the exchange on the request for the subpoena. So here, the hearing officer asked the district's representative, would it be possible to bring in those police officers? The principal responded, I have no idea what that process would look like. And then everyone moved forward and never addressed it again. So that was an easy situation for the commissioner to say that was an abuse of discretion. There needed to be a ruling on yes or no on police officer subpoena. So this decision, 2022, ends with the following paragraph. This is one of several recent appeals resulting in the expungement of long-term suspensions based on inadequate proof or procedural violations. Will the parents ultimately prevail on appeal? These are Pyrrhic victories for parents whose children were improperly suspended for weeks or months. School districts should carefully consider the nature and quality of proof against students before pursuing long-term suspensions. Should they choose to proceed, school districts must ensure the assiduous protection of students' due process rights. So the TLDR version is, if you're going to suspend a student for many months, you better bring your A game to the hearing. And here's a few, I don't want to there's several variations on the scrutiny of proof theme, as you can tell by that paragraph. So I've just listed three more that you have in your materials and you can refer to. The bomb threat one is very interesting for both inadequate proof and inadequate handwriting analysis. I learned a lot about lay handwriting analyses through doing this, which are permissible and admissible, but it doesn't mean that you can just do a bad job. Lack of proof, gummy bear ingestion. So this was we've actually unfortunately had this fact pattern in several appeals, which is student consumes a gummy that contains THC, ends up hospitalized, or there's an adverse health reaction. And that was what happened in this case. And the district never proved, though, anything to counter the student's explanation that she did not know this gummy bear contained THC. And the third is just a personal favorite, what I call the shoving appeal. These were two high school football players who were talking to a teacher in the hallway. And in the course of conversation and being silly, one of the football players gives the female teacher a kind of Elaine from Seinfeld, get out kind of push. And all we know is she stepped back. That's all we know from the record. So they go to a hearing, and the superintendent seems very understanding. The kids are apologetic. The parents are there, and they're livid too. They're like, you never put your hands on a teacher. I've talked to them about this. But magically, in the back room of who comes up with suspensions length, both these kids got socked with months-long suspensions. So the commissioner issued an interim order ordering them back to school. And I don't know why, but this line always makes me laugh that I included. Record supports a finding that the student engaged in innocent, if ill-advised jocularity that did not warrant a long-term suspension. And look, AI is the gift that keeps on giving. Here is our pensive student wondering about the contents of her gummy bear. All right, and Erika will take the next one.
In the appeal of NVD, a student was given a suspension for several months. Her parents then enrolled her into a private school. When she returned to the public school the following fall, surprise, her suspension was waiting for her. The commissioner rejected the suspension and abeyance theory, reasoning that a suspension represents a district's determination as to the appropriate consequence for misconduct. This decision cites much of the above evidence, including the region's resolution and New York's promises in its ESSA plan. The commissioner also rejected the argument that this will allow rich families to avoid suspensions. First, non-public schools are under no obligation to admit students. And second, a parent's decision to remove a student from school or enroll her or him in a new educational environment, whether temporarily or permanently, is likely based on numerous considerations and not taken lightly.
Yeah, and if It's surely not at all clear, but what I was going for with this picture was a non-copyrighted Back to the Future like situation, because this involves temporal displacement of suspensions. But I know it's not as good as the hot stove and the rubber hose. Um, well, before I forget, for my in-person attendees, and I'll hold them up for those watching as well, so you know they exist. So we're talking about old decisions, and you may wonder, where am I finding these things? So the record of the first commissioner's decisions up through 1913 is in a greatest hits volume that the state education department has. It is on file with the state library. And these are grouped. So it's in, there was a big fire. We were just discussing this earlier, and many records were destroyed, including a lot of original commissioner's decisions. But the department had some, and interestingly, the forward indicates, had to write to schools and ask, hey, you got any commissioner's decisions you could share with me? So the result was to group things by topic and kind of show what the department's approach has been and how it's changed, if it's changed. So we have this. You can tell they're dated decisions. One of the categories is religious garb. And it's just, the nomenclature of the time. So you'll find some gems in there. After that, commissioner decisions were printed in the State Department reports, which was a official New York State publication. We were one of many. We had to compete with the Water Board and the Planning Board and a lot of dry topic material. We're clearly the all-stars of the State Department reports. That brings us up to about the 1950s, and then the 50s through 2009 are those red volumes familiar to anyone who practices in this field. Thereafter, they're just on our website. So Me2, can you help? Those who have chosen to attend get the added benefit of flipping through these books. But anyone on Zoom, if you want to come to Albany, you can look through them. All right, so one more appeal, I think, that really illustrates this concern for students, excessive punishment, what are we doing, is appeal of BA. And the memorable holding of this appeal was that the district did not prove a conspiracy to beat another student's ass. And pardon the language, which is the actual language used amongst these children. So on December 22nd, 2021, while serving an out-of-school suspension, the student at issue, student A, received a message from a friend, student B, on social media. Student B asked, should I jump student C? And Erika has kindly agreed that we're going to give you a little table read as best we can of the ensuing conversation. So Erika is going to be student A.
Go ahead. You should film it, though, if you do.
I will.
Okay, send that shit to me after you do it.
Okay.
I'm gonna laugh my ass off so hard if you bear his ass.
And the parties seem to agree bear his rear end was beat his rear end. So this is the conversation we have. And what happens? Student C gets beat up by student B. No filming, though. So it wasn't as hysterical as student A had hoped. So the charge against student A was that he conspired with student B to attack student C. The commissioner held, under a dictionary definition or the penal law definition, take your pick, this text conversation did not amount to a conspiracy. At most, the commissioner said, these messages merely established that the student encouraged student B's plan to attack student C. Although the student suggested filming the proposed fight, there was no evidence that it was filmed, nor did respondent call student B as a witness, the other co-conspirator. Student A offered exculpatory testimony, including his explanation that he did not think student B was serious about attacking student C, because student B always says he's going to do stuff, but never does. So I've got one more concluding paragraph in this one, if you're noting a theme, to help guide the field. Students must understand that impulsive and juvenile comments can have real-world consequences. Punitive and exclusionary discipline, however, will not impart that lesson. The facts of this appeal prove the point. The student sent the messages while suspended for a previous infraction. Learning and success are not solely academic in nature. They're dependent on the social, emotional support that schools are required to provide. Instead of punishment, respondents should have helped the student learn to assume and accept responsibility for his own behavior while simultaneously establishing remedial supports to foster and thus augment the student's emotional intelligence. Punishment for its own sake does not reform, it only creates cycles of resentment and distrust. And I think it sounds a lot like Appeal of Cuffy, some of these decisions from the 70s era. AI is the gift that keeps on giving. There's Erika, student A, laughing his butt off while texting.
The appeal of TB is an important appeal, even if it wasn't a winner for the parent. A high schooler, in the course of fighting with his girlfriend, took a video of her naked and uploaded it to social media. While he took it down, the video circulated online because, as we know, nothing just appears on the internet. The girlfriend was humiliated and the student was suspended for a year. Whether a suspension is excessive has always been, since the 19th century, was within the commissioner's subjective discretion. Appeal of DB represented the first effort to explain what factors are relevant to this determination, which you can see on the screen. One of them, how the district has attempted to help the student learn and assume to accept responsibility for their behavior, is derived from the appeal we just discussed. It reflects that even when a child has engaged in misconduct, they remain part of the school community. Schools have to be thinking about how a child can be best reintegrated into the school community and not just being forgotten for several months.
Mm-hmm. Thank you. We have our second Zoom code for everybody attending virtually. It is SD17. SD17. All right. The next one is the row on Restaurant Row. So this is about a rumble that occurred at an abandoned McDonald's in Long Island. And one of our colleagues is from the area and was like, oh, I know this area. So this student who was charged was present when a fight occurred. The district had shifting explanations for the extent of the student's culpability, eventually landing on the student, quote, knew a fight would occur and hung around anyway. Commissioners reasoned that even if the student had that knowledge, the district did not allege that she instigated or encouraged the parties to fight. She also held the student was not obligated to prevent a fight between others or report such misconduct. So there's no good Samaritan requirement for students. And this is 3 of 3 that I've been reading with an interesting conclusion. Here was the takeaway from this one. While respondent was justified in investigating the incident, once it learned the student didn't participate in the altercation and in fact sought to provide aid to her friend, its decision to pursue discipline was indefensible. I'm particularly concerned that no one appears to have considered the effect of these events on the student. Witnessing an assault or a seizure, one of the students who was attacked had a seizure afterward, is a frightening experience, particularly for a 14-year-old. Thus, in addition to inaccurately assessing the student's culpability, the administrators involved in this incident should have demonstrated greater empathy under the circumstances. And AI has given us this gem of the abandoned McDonald's. AI, by the way, said it could not show students fighting. And I said, oh, okay, can you show them wrestling? And this was wrestling. I didn't do wrestling, but this looks a lot like fighting to me. And our Erika gets the last and most recent.
The most recent, this is Appeal of NT. This was one of the first appeals that I drafted, and the facts really struck a nerve with me. And I thought about this case for a long time afterward. This is another hearing officer error appeal because despite 3 attempts, the hearing officer brushed off attempts by the petitioner to introduce relevant and exculpatory evidence. The commissioner also held alternative. So a little backtracking. The student here was a transplant student, so she hadn't been she'd only been a student of the school for a couple years. And last September, there had been a few schools throughout the state who had gotten notified threats of school shootings or bombings, and it made it made a lot of commotion around the state. And one of these schools was the student school here. And during a conversation with the student who had a history of being bullied by other students in the school district, the student was Snapchatting her friend, and her friend had asked her, "Did you see this Facebook post?" And the student said, "Oh yeah, I saw it. I saw it. Whatever." Her friend said, "Send it to me." And our student fell asleep, and she woke up the next morning not having sent the photo. So she woke up to messages of her friend calling her a liar, and in a panic, she claims that she faked a screenshot that said, "Newfane and Lockport schools, better watch out. We finna shoot that bitch," and added a laugh crying emoji. And as we know, she had been suspended for a full calendar year for making a threat of mass harm. And the commissioner held alternatively that a year-long suspension for the immortal message of "we finna shoot that bitch" was excessive. The commissioner applied the DB factors as follows. It's unreasonable to expect a 12-year-old to predict or understand that a message she sent to a classmate, which she believed would be interpreted within the context of a larger discussion, would become widely distributed. With respect to prior offenses, the student's anecdotal record reveals a handful of incidents over the past 2 years that are relatively minor in nature, such as cutting class, cursing, and excessive lateness. And other than offering placement in an alternative educational setting during her suspension, there's no evidence that the district attempted to help the student learn to assume and accept responsibility for her behavior. And this, in my opinion, this decision also reflects on an even bigger issue. Because Dan and I had heard the recording of the hearing while I was, reviewing this appeal, and I had made a comment that this hearing officer sounded very old. He sounded like Winnie the Pooh, and it came out later on that by the time we got the appeal, the hearing officer had already passed away. He passed away from old age, I'm guessing. And that kind of shed light on an even a bigger issue, which I can't put any more eloquently than trying to explain a meme as a 12-year-old to a 70 to 80-year-old hearing officer. There's a huge disconnect that a 12-year-old can see why joking about a school shooting would be funny, but a 70-year-old cannot. And they don't understand why somebody would joke about that as a 12-year-old. And post Columbine, I feel like there is a huge discrepancy and disparity in just dissonance between an older generation who grew up before Columbine and a group of students, including myself, who grew up in a public school after the effects of Columbine. And we were far enough removed from it to not understand the severity of some threats that people make because we were kids. And, it was always so far removed from our experience in our lives that somebody who was an adult when Columbine happened and when all these violent attacks happened at schools, they were adults and they understood the severity of it. And trying to explain it to somebody who grew up with all this violence being normalized, there's a huge disconnect. And I think that disconnect shows itself in these excessive punishments that don't prove anything.
Yeah, it's a great point that this post-Columbine generation had to process or not process some of these events. And I think one of the themes you've seen here is who has the power. And people were very comfortable for the 19th century and most of the 20th century to say the adults have the power and we don't really care what students think or say because you need to get in line. But since the 60s, 70s, we see a growing interest in, well, what is actually best for kids? That in some way or another, people in schools, people who work with schools have been drawn to this profession. And it's not simply to be an adult and tell other people how it is. It's because you want to serve kids in the best way you can. And I think that the approach of these recent appeals is a good framework and shows the best of what we know as to how to do that best. So Erika's going to share, you have simplified versions here, but some thoughts from some great thinkers in this area.
So Fatima Berry had said, I know firsthand what it feels like to make a mistake and not be given grace. I want students to know that not only do I understand what they are going through, but they can grow through it and truly excel. Derek Black had said, training and supportive approaches to discipline cannot guarantee school shootings won't happen, but research says the best chance of reducing violence and also improving the overall academic achievement and environment of schools rests in rejecting punitive school discipline and replacing it with supportive systems. And our own Commissioner Betty Rosa had said, education lies at the core of effective disciplinary measure. We're often asked what we would recommend to schools or boards on disciplinary measures. Our advice is simple. What would you want if the student who's being disciplined was your child or sibling or niece, nephew, cousin, etc.? The answer to that question would lead you to the approach of these recent appeals.
Yeah.
And I can't speak for myself because I have no children.
Yeah. No, Erika's that's 100%. And that I think is whenever I see all the kids involved in these appeals, I have a 12-year-old and a 9-year-old. I think, what would I want for them and what would be best for them? So, so we made it to the last slide. No more AI images. I'm so sorry. But it's been we have ample time for questions, and it's been an absolute pleasure. Thank you. So why don't we, I know you've been itching to ask one.
Lawyers have a huge role. When I was a young lawyer, before I got no, I do it. As a young lawyer, there's a case up in Burton, Westfield, the rural district here. And a young man was brought before the school board. The school board's lawyer came in, they had a hearing, and this young man had been accused of basically being the large.
Shell. Oh, you are so good.
Gotcha.
Shell is so good. In one of my lives, I chair the Government Law Center, and Chell really runs it all there. So, in any event, so I was called by one of my partners who knew his mother, and I went up. I knew nothing about any of this. So I went up, and what happened was on a Saturday night, he was out on a rural stretch of Albany County, and he had bragged to everybody that he was selling marijuana, had all this marijuana, all this drug talk. And his deputy sheriffs came along, they arrested him, reported to the school, and the school suspended him. Mm-hmm. So they had a hearing. So I went up, and it turned out that no one had ever tested the substance they took from him, which, by the way, was hay.
Right.
Okay.
Yep.
So I didn't know anything about the education law, but I knew Gordon Ombach, who lived in my neighborhood. He was a commissioner. And I knew Bob Stone, who turned out to be my client at the end of his life. He was a giant. I know you must have heard of him, right? He was a giant counsel to the education department. So I did a 310 appeal. And I went in, and they both heard the appeal and ultimately restored him back to school because of a lack of proof. And these rural schools in this situation were, they're all publicly elected. Mm-hmm. And to think that some kid's accused of being a drug dealer and they took action right away, got rid of him, that was very popular. But the reason a lawyer gets involved is to basically create some justice in those situations and do the things you just talked about here. Ultimately, this young man graduated from high school, graduated from college, and he became a weatherman in the Air Force. So when the planes came out of England and went down and took out Gaddafi in Libya, he was the one who had done all the weather reports to make that happen. And so I reported that back to Commissioner Ombach, and to Counsel, Bob Stone. And they said, yeah, I mean, you don't know where someone's going to turn out. But that experience for him going through that and suddenly becoming a target really was a strong lesson for him that he took. So your point about education works, and it does. So
Yeah.
I appreciate you being here today, but I think that 310 mechanism is something that is really an important thing to have there. It's cheaper than going to court. It can bring a much quicker decision. You're talking to people who understand what education law is all about.
Yeah.
So thank you for being here.
Thank you for that. Yeah, I was going to say this could have and should have been a slide in the presentation. So thank you. On that note, I will say about this education law 310 being a good remedy. As far as to my knowledge, there's only one other state that has something like this in Rhode Island, and it's not quite up to the level where we are. It's you get like someone like us writes a report and recommendation, and then their commissioner signs off on it. But they're doing a dozen a year on relatively non-controversial topics. When I talk to other states and explain the breadth and the number of these appeals, that it's 200 per year, it's on basically anything that happens in the school system, their minds are blown. Kate, please.
Would you mind using the microphone in front of you? You press push and keep holding it.
Okay, pretty loud though. So all right, I'll tone it down then. So to sort of looking at Erika's point about really taking things in context and processing, I know that one of the limitations in the realms of education law is that you can't really impose restorative justice, counseling, volunteering, like mentorship programs. I'm curious though, because one of the mechanisms that's kind of a workaround I know a lot of districts use is you've done this, we're going to suspend you, but hold it in abeyance if you complete this mentorship program, this volunteer program, whatever it might be, to sort of facilitate addressing the actual issue, processing it instead of going to punishment. But if holding suspensions in abeyance is no longer permissible, I'm wondering if you can differentiate between that private school case and how that might impact the restorative justice in holding it in abeyance.
But see, I don't want to say I had the same type of question, but when it comes to the remedies or the available punishments in 3214, that is something that I've noticed too. It's either suspension or nothing. They don't offer counseling services or the abeyance. The abeyance process reminds me of when I worked in family court. That was the adjournment and contemplation of dismissal for kids who committed juvenile offenses. And if they're, even if our own criminal justice system has these methods available where you are in trouble, you did something wrong, but as long as you go through the steps to rehabilitate yourself, then we will drop that off your record. It's just not in 3214 unless you have a disability, or the only time counseling is recommended is when the student has a disability or has an IEP. And I think that's kind of where, I don't know if we're behind the mark on it with 3214 or what, but I think the changes need to be done legislatively to.
So then what you're saying is that commissioner's appeal has in effect ended the district's ability to enter into those agreements with the parent, and it would have to be legislative.
No, I think we can reconcile them. And I know we sped through a lot of these like long decisions at the end. So in that one, the suspension was, let's say, a year. And the child spent a year at the private school and then came back and they're like, I put it on hold. And now it's still here. Whereas a lot of the deals the districts work out, it's like the suspension is a year, but you can get it to a week if you do these things. So I think they can be reconciled in terms of you pick a date when it ends and you have negotiation within that, but you can't then tack it on forever. Yeah. I mean, what if she went to like Massachusetts for 3 years and then came back? I mean, that's another thing where it seemed to make sense under the facts of this appeal, because it's like you just went to the school 10 minutes away, but you can't have a doctrine that makes sense for that and then doesn't make sense 3 years later. So thank you. That's a great question.
Thank you. I was just worried.
Yeah. Whitney, I hope you're not going to say, I didn't want this to be a CLE, actually.
Okay, thank you so much. This was excellent. You guys did a great job. And it's been really fascinating to see it all put together from a historical perspective. Um, I had one specific question of whether the MDR, because it's from 504, is the MDR a national requirement?
Yes.
Okay.
It actually started as a Supreme Court holding
Okay.
and then was codified
Okay. I wonder
in
if there are
federal.
variations in how states implement that. And then my second question is whether it's evident from the text of Appeal of Joseph that the suspension came on the heels of Columbine.
Yes.
That is right there in the decision. Okay,
Yep.
good. I don't think I noticed that before, that it was right there in the appeal, but that's a really good
Yeah.
distinction for those, the defense that we see where, oh, you've upheld an 18-month suspension. Okay, thank you. Oh, and this book was amazing. I looked at the intro to the judicial decisions compilation,
Mhm.
and it was so fascinating. I think it gave me a lot more ideas for an argument I'm trying to make about how these are legal proceedings, and that disclosures are required to defend them.
Perfect.
And it also had like a side note about how all 800 of these decisions were compiled and then destroyed in the state capitol fire.
The manuscript.
And
Yes.
then they had to do it again.
Yeah.
So that's
Yeah.
amazing.
That's okay.
Yes.
Is there ever, so I know that you said, so for the fair hearing, you would need that, like, hearing officer is essentially the superintendent or their designee, right? Is there ever a case where they have an independent person? I mean, there is.
Yeah,
Yes,
like
most.
the Winnie the Pooh hearing officer,
Yeah.
I believe he was hired through BOCES.
There
Yeah,
are,
okay.
yes, there are BOCES cooperative service agreements that do it. Also, sometimes private practice attorneys will do it.
So I was just thinking like arbitration stuff.
Yeah, yeah. I believe
And-
the statute says impartial hearing officer, but there have been decisions where if the superintendent makes the punishment, then they can't be the hearing officer, but there are other cases where they can be. It's very confusing.
Yeah. And I will, to be fair to some of the districts in these situations, that it's the hearing has, if you want a child to remain continuously suspended, you would have to hold the hearing on day 5 of the suspension, because there are other commissioners' decisions saying you don't, until you finish the hearing, you only get 5 days. So if it takes 6 to 8 days, the student goes back in. So many of them are motivated to we got to run through these hearings. I think it doesn't excuse some of what we've seen. Like, I have a police report about drugs, but I didn't bring that to the hearing. But certainly the time constraint is real, especially if it's a disputed case and you needed to talk to a lot of witnesses.
We have a number of, oh yeah, please go ahead and then we'll do some questions from Zoom.
I just pressed this. Wow. Such power. Hi, I'm Brad Hansen. I actually am an advocate. I work for an organization called Families Together in New York State, and I help organize the Solutions Not Suspensions campaign, which is about the Solutions Not Suspensions Act, New York State legislation. I'm curious, in your research for this, did you come across this bill and the active movement to pass it, which it would do a number of things. It would limit suspensions almost entirely for children pre-K through 3rd grade. It would look at subjective violations such as willful defiance, dress code violations, tardiness, and prohibit the use of those. It would limit the maximum length of suspensions to 20 days. And a number of other things like forcing schools to rewrite their codes of conduct so that they would have to use graduated tier approaches and interventions before they could use a suspension. Is that I'm here literally because I'm not an attorney, but some attorneys that are part of the coalition heard about this, and hearing student discipline revolution sounds very good to people actively trying to change state law. Is this something you're aware of? And are you free May 11th? Because we're actually having an advocacy day at the state capitol.
Well, yes. So I can say yes, the department's familiar with this. We have a government relations team, and Office of Counsel works in conjunction with them. So we've seen versions of the bills. And the department is always available to everyone to offer technical assistance on pending bills. You know, that's in the professions is another example where we very rarely, so 3214 was the exception because we wrote it, but we very rarely take positions on legislation, but we do remain available to review and say, here is our best thinking. So I believe the department has done that in the past and remains willing to do so. Jill, did you say I didn't want to neglect our Zoom
Yeah,
questions?
we have a number of questions from Zoom. So on the subject of solutions, not suspensions, and some of the, I guess, guidance that has come around, the educational value, and also balancing students' due process rights. How does the commissioner, maybe in decisions or in guidance, and state ed maybe broadly, balance that with, the reality of violence and ongoing threats and substance abuse? I mean, it seems like there's kind of tension, right, between kind of these values and, some of what we're hearing from educators and administrators.
I think the balance has to be made on an almost case by case basis because kind of giving like the real threat of violence. This is another instance that actually happened this past weekend in Clinton Central School District. 3 students were just expelled for making a threat of mass harm for today. They threatened the middle school cafeteria would be shot up today because the Columbine anniversary is on Monday. And I guess one of the students had an obsession with Columbine and Sandy Hook. But in that case, I believe it happened off campus. It happened on a weekend. So the sheriff's office took the responsibility and took action for that. And then the school expelled. And I think on a case by case basis, like in that case, the threat was real. Law enforcement took action first, and then the school took action following that. When you compare it to the appeal of NT, where they didn't really have much to stand on, and at that, the family court was also involved, the sheriff's office was involved in that case too, and that was dropped. So it's kind of like you have to, I don't want to say you have to use your discretion, but there are some where you have to like think about how reasonable it is and how likely it is that this violence would happen. And I don't want to say people do make the wrong choices sometimes, but I don't know. I don't know where to go after that. Yeah.
And I think that in both the recent decision, we've highlighted the ones for you that have the jazziest quotes or the most interesting facts, but there's also decisions upholding lengthy suspensions reluctantly under the facts to say this was an actual, you had a weapon, and well, this isn't what I would have done. Reluctantly, I'm going to leave this one to you as the local. So as Erika says that, and there can be, I'm thinking of a pending one we have now where a child made a serious and potentially real threat, but is now in an inpatient treatment facility. So what happened, whether it's a real risk and what's going on with the family is going to differ based on the situation.
Thank you.
Mm-hmm.
We have a few other questions from Zoom too. In situations where kind of these longer suspensions are deemed necessary, what resources are maybe provided to schools and districts to kind of make sure there is educational value, right, in the suspension? Is there guidance on this?
No, I think the best that we've found in our decisions thus far, so some of them have specific full day programs. You're suspended and now you're going to get this program. This is an area where, again, in the nuance, there's goods and bads with using Zoom to deliver education to kids. On the one hand, it's creating new access, but on the other hand, it can be, oh, we'll just put them in front of a screen and we're not checking in that they're getting, what they need. That's probably the best solution to have because I can say hearing from districts trying to quickly obtain and patch together tutoring services is very challenging.
And I think finally, we heard a lot about hearing officers and some of the kind of whether, appeals are sustained or, decisions are sustained, right? What kind of support and training is available to hearing officers in school districts kind of going through these processes?
Yeah, so the BOCES programs, I can think of a very good one out in Rochester. I've met some of the people involved with who they have supervisors, they have training, they regularly get together to talk about it. But more often than not, it can just be an attorney. And I think you see in the decisions, we expect attorneys to know a lot of this is not technical knowledge, that it's not like, oh, you were unaware of Commissioner's Regulation 100.2, blah, blah, blah. It's really just someone's in front of you screaming, I want to put this in and I want to do this. And you either didn't deal with it or brush them off or so no, we don't have training specifically for them, but I think having someone with a legal background is at least the best, should ideally provide you with what you need. Okay, please.
Sorry, it's me again. So speaking about sort of hearing officers and knowledge and the peripheral aspects of things, I mean, when you're dealing with the more serious charges like a gun possession, potentially narcotics, and there's a criminal parallel action, or there's a student with a disability, 504 or special education, have you come across, or is the department looking at maybe issuing some guidance with regards to sort of that process and pitfalls to make sure that the peripheral actors are aware of what's going on? Say that, for instance, I heard from potentially the same age as the hearing officer you described, a gentleman who was a hearing officer for special education purposes saying he was going to subpoena a student and demand that they answer whether or not they had brought that gun to school before he decided if the manifestation was correctly conducted, at which point there were some comments, luckily people who had a little bit more knowledge about Fifth Amendment rights and sworn testimony and potential pitfalls were there to speak. But I'm curious about that overlap. Do you see pitfalls and issues? Is there collaboration, or is it sort of a district by district, do the best you can kind of approach?
That's interesting. I will let Erika talk about her experience with family court, but there's a commissioner decision saying family court, education, these are separate spheres and we can both do what we want. That seems to be the prevailing philosophy to me. Whereas I feel like if it's serious enough that it's landed in family court, it's probably better to let them take the lead.
Yeah.
Go ahead.
Yeah, I agree. Like how we mentioned earlier, services like the abeyances and everything. If a student does need those services and it's that severe, I like to believe that family court or some other organization or program or something is involved with the child, because the way that I think about it is if family court is involved and they're taking action, the school should kind of follow suit with that. And the same goes for if a student got charged with criminal possession of a controlled substance, they're in family court, those charges get dropped, but the school is still trying to impose punishment on them. I've seen decisions where the commissioner has said, family court already decided this. The school doesn't need to get involved, or the school's involvement shouldn't really have an effect on the student. you know? But
And just sort of to that end, not looking at family court, but true criminal court, which is where
Yes,
it often
that too,
came
yeah.
up. I mean, the beyond a reasonable doubt standard. I know that a lot of the approach is sort of looking at that versus a preponderance
Right.
of the evidence that you're looking at and clear and convincing. That was also something that I know there have been times where, luckily, when working with districts, they have actually said, like, you might want to hold off on having the hearing
Yes.
because that can be subpoenaed and entered into the record.
Yeah.
So, I mean, just some of that, like the school district being aware of the potential farther ramifications, not just, hey, we're
Yeah.
putting you out for 2 weeks, but now you've stated under oath that you did X, Y, or Z.
Yes, that actually reminds me of a decision I read from, I think it was like the 80s or 90s. A child was arrested and he was picked up on something. He went to go have they had his suspension hearing scheduled, but he wasn't there because he got arrested on another charge. So he was in custody, and we actually struck down his suspension because he wasn't there. And I think that's when the commissioner kind of addressed, you can't. We understand there are other proceedings going on. Those should probably take precedence before
Yeah.
the procedure should be altered to accommodate the student, because if he's not here, you can't be suspending him over something that he's already in jail for, because he's not there to, he still has his own procedural rights separate from the criminal proceeding. But again, if those charges are dropped, the school can't suspend him for drug possession that he got charged with off campus.
Oh, off campus.
And
I
off
was going to
campus.
say, like,
Yes,
I've seen
yes.
it happen because they're like, it's a different standard and the suspension
yeah.
sometimes.
The one I believe, I think he got charged with like something that conduct that occurred off campus, and then the schools tried to punish him for that just because he got arrested. Yeah.
All right.
So thank you, everyone. We are past time. Let's hear it for our presenters. And again, those of you looking for continuing legal education credit, if you are here in the room with us, please complete and sign your forms and give them to my colleague Lisa outside the room. If you are on Zoom, you've received instructions by email and forms as well. So thank you all and have a great weekend.